Good morning, sir. Can you see and hear us?
Yes, thank you very much.
May we please call Mr. Harbinson?
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Could you confirm your full name, please, Mr. Harbinson?
Gerald Owen Harbinson.
You should have in a bundle in front of you a hard copy of a witness statement in your name, dated the 17th of October of this year. Could you turn, please, to page 67 of that statement? Do you have a copy with a visible signature?
I do.
Is that your signature?
It is.
I understand there is a correction you wish to make to paragraph 70 of this statement. Is that right?
That's correct.
Would you like to tell us what that is?
There are two names there, Brian Sharkey and Ray Platt. That should have read Ray Pratt, not Ray Platt.
With that correction made, are the contents of the statement true to the best of your knowledge and belief?
They are.
For the purposes of the transcript, the reference for the statement is WITN 081 50100. Thank you for coming to the inquiry to assist it in its work and for providing the witness statement that you have. As you know, I will be asking questions on behalf of the inquiry. You worked for the Post Office for 12 years, from 1998 to April 2010, when you moved to Royal Mail. Is that right?
That's correct.
And your first role was as a TV inquiry officer. Can you explain, please, what this role involved?
That was going out on site to visit properties that you were sent lists to visit, to check on the whether or not they were operating a TV with or without a licence.
And in the year 2000, you were internally recruited into the Post Office security team as an investigation manager. Is that right?
Yeah, that's correct.
And you held this role until early 2005, when you became a compliance manager,
That's correct.
before becoming a financial investigator later in the same year.
That's correct.
Did you remain in a financial investigation role until you left the Post Office in 2010?
Yes, I did.
You have provided some clarification in your statement at paragraph 6 to the effect that the word manager in the job title of investigation manager did not in fact mean that you held a managing position. Is that right?
That's correct.
So you were an investigator conducting investigations rather than a manager of those conducting investigations.
That's correct.
You say in your statement at paragraph 7 that there was a big intake into the security team at around the time you were internally recruited in the year 2000, with about 15 to 20 people being recruited at that point.
That's correct.
Were these people recruited internally as you were?
I genuinely don't know the answer to that, but I believe they were.
Do you know why there was a recruitment drive at this point in time?
I wasn't aware of the reason. I know it covered both Post Office and Royal Mail.
Did you have any experience in criminal investigations or criminal law when you became an investigator for the Post Office?
No.
You recall having training early on, which took place over the course of a few weeks, and you described this course at paragraph 61 of your statement. Could we have that on screen, please? It's page 24 of Mr. Harbinson's statement, WITN. Thank you. Page 24. A little further down at 61, please. And you say here, when I first joined the security team as an investigation manager, very early on, I was required to attend a formal training course at a college in Milton Keynes, which was led by 2 or 3 senior members of the security team. I recall that Mick Matthews was one of the trainers, and I remember he was very thorough in his teaching. Whilst I cannot remember all the modules we were required to learn, I believe that they did cover the following: the duties of investigators to conduct full and thorough investigations, taking witness statements in the course of an investigation, conducting interviews under caution, obtaining evidence in the course of an investigation, seeking evidence from third parties who might hold relevant evidence, and drafting investigation reports, and the legislation relevant to our role. In order to continue in the role of an investigation manager, you had to pass an exam at the end of the course. I cannot remember the specific details of that exam, but I do recall passing it. Is it right that this training was provided internally by Post Office security team members rather than being provided by external trainers?
That is correct.
Did your initial training cover disclosure, as far as you can remember?
I can't remember that initial training on that subject.
You say at paragraph 10 of your statement that you also received training in the form of shadowing. How did that work?
When you first joined a team, you would not be allowed to lead an investigation. You would always be a second or third body to the investigation. You'd be shadowing and listening and watching. And back in the office, you would be taking instructions and listening to what the other investigators said about the roles that they were performing.
Could you explain, please, the structure of your team when you first started as an investigator and how cases were allocated within the team? Do refer to your statement if you need to.
When you say the structure of the team, do you mean the investigation team or the team that I was in?
The team that you were in. So you cover this at paragraph 11 of your statement. And you say here you had team leaders.
Oh, right. Yeah. Okay, I was in a team. I had a team leader. The team leader at that time, I think, was Tony Atting. There would be, the team consisted of about half a dozen investigators. That was the team that I was in. The investigation team as a whole would be team leaders around the country with the investigators, and then there was the back to the investigation senior people who run the investigation side of things.
And you say that you, when you started in the role, you carried out investigations in relation to potential pension allowance fraud to help identify whether such fraud was committed internally at the post office or externally.
That is correct.
And you say at paragraph 12, you also investigated cases where there was a discovery of a cash shortfall at a post office branch following an audit.
That's correct.
Where there was a discovery of an apparent cash shortfall at a post office branch, how did the investigation team become involved?
That would come through from the casework management team, or from the audit team, and they would be told the branch that had the shortfall, and then the team leader would allocate the people that would go out to do the investigation.
You address the process followed once an investigation commenced in an apparent shortfall case at paragraph 13 of your statement. If we could have that on screen, please. It's page 5 of Mr. Harbinson's statement. And you say this: when carrying out an investigation, I would collate the necessary records and documents, such as reports that the auditor had printed from the Harbinson system on the day, take witness statements from relevant persons, and conduct interviews under caution with the relevant persons, for example, the SPM. Taking this in stages, is it right that the Harbinson data you were considering at this stage was that contained in the printout from the Harbinson system obtained from the counter in the branch?
That is correct.
So you were simply looking at the record of what the Harbinson system said should be held in a branch against the record of what the auditors actually found to be held in the branch.
That would be part of the records that would come off. The audit team could print off quite a few days or weeks of information from the system at that time, so there'd be quite a roll of information. I'm not sure exactly how far, I can't remember how far they could go back, but it would be quite an extensive roll of information that was printed off.
But it was, they were reports which were printed off from the counter in the branch.
That's correct.
Where an audit identified a discrepancy between the Harbinson system reports and what was actually held at branch, how soon would you interview the sub-postmaster or relevant member of staff?
That would depend. That could happen almost immediately. It could be days later, depending on the circumstances of the information and where the sub postmaster was, or who else was in the office. It could be over a period of time, but is often fairly early in the investigation.
You go on at paragraph 14 of your statement to say, following this, you would write up, excuse me, you would write up a report of findings and open a case file. The report you refer to here, is that the report which would go to the criminal law team, the legal report produced by investigators?
That report would eventually arrive with the criminal law team, yes.
But the report of findings which you refer to here, that's referring to the legal report, is it?
It is, yes.
Did you ever conduct further inquiries or seek further evidence after conducting interviews, but before writing that report for the criminal law team?
I genuinely can't remember myself, but it's something you would do, is if you didn't have all the information that you were going to submit in your report at that time, you might do further interviews with other people or subsequent interviews with the same person. That would depend on a case by case, but I can't recall.
Is it right that you would send the case file, once fully prepared, to your team leader?
It would normally go through the team leader, yes.
Was it any part of your team leader's role, on receipt of the file, to review the evidence to determine whether further action should be taken in that case?
I can't remember that part of it. I think they would give you advice prior to writing your report as part of the team. It's such a long time ago, I'm struggling to remember that. I would only be guessing now, I can't remember.
You say in your statement at paragraph 14 that your team leader would send the file to the casework management team to check it from a procedural standpoint. What do you mean by procedural standpoint here?
I think I'm talking about almost like the compliance to make sure all the documents were there that were, you know, if they were listed as items in the file, that they were actually in the file. Everything was complete. It was going to the right place. It was like a check on it, really, I believe. I'd never worked in casework management, so I'm not completely sure.
You also say in your statement at paragraph 14 that the report was then sent to the head of the security team. Is that right?
I believe that's where it went, yes.
You refer to Phil Gerrish, Tony Utting and John Scott having held the role of head of security at various points. Do you recall Tony Marsh at all?
I know of Tony Marsh. I think he was always the senior person in both Royal Mail and Post Office at the same time. He was very senior. I don't recall him being in charge of the investigation team.
Do you recall him holding the role of head of security prior to John Scott?
I thought the head of security prior to John Scott was Phil Gerrish, and Tony Marsh was senior to Phil Gerrish. So there was Post Office, and Royal Mail. Phil Gerrish, head of Post Office, and I thought Tony Marsh was head of both groups, Royal Mail and Post Office, but my memory is poor in that area, sorry.
Do you recall that there was a role entitled National Internal Crime and Investigations Manager when you were an investigator?
I don't remember that title, I'm sorry.
Do you think that might have been the role which Mr. Gerrish and Mr. Utting held rather than the overarching head of security role?
I'd be guessing now, I can't remember.
Could we have paragraph 15 of Mr. Harbinson's statement on screen, please? It's page 5. Towards the bottom, that's it. You say here, once the case file was with the head of the security team, it is my understanding that they would then liaise with the case management to get it passed on to the criminal law team in the POL. I do not know if there were any specific factors considered to determine whether to pass it on or not, or whether all case files were passed on in any event, other than on an evidential basis, which I deal with in paragraphs 18 and 19 below. I do not believe that I had any involvement with liaising directly with any other POL department during my role as an investigation manager. I believe that any other necessary cross-department liaison was dealt with by colleagues in a more senior position to me or with casework management. As far as you can recall, did the head of security review the evidence in a case before the case was transferred to the criminal law team to determine whether further action should be taken in the case?
I don't know. I don't know what the head of the security did with the documents or what evaluation he made of them.
In terms of the decision on whether someone should be prosecuted, You say at paragraph 16 of your statement that you believe it was always the decision of the criminal law team whether to pursue a criminal prosecution or not, and you do not recall that decision ever being made by anyone in the security team. Do you recall the title of designated prosecution authority from the time you were an investigator?
I don't recall that position. No, I don't remember it clearly.
Could we scroll down, please, to paragraph 18 of your statement? You say here, in the event that an incident I had investigated was being prosecuted, I would continue to assist the criminal law team on an evidential basis. For example, if the criminal law team required additional evidence, the criminal law team or my team leader would inform me, and I'd carry out additional work to obtain such evidence, for example, taking an additional witness statement. Due to the passage of time, I am unable to recall any specific examples of this occurring. After a decision had been made to prosecute, would it be fair to say that any further inquiries or evidence gathering would be reactive and done when required by the criminal law team?
I'm sorry, I didn't understand that.
So after a decision has been made to prosecute,
Yes.
so you've done your legal report, it's gone to the criminal law team, and a decision has been made to prosecute the individual. With reference to this paragraph that we've just looked at, were your further inquiries or evidence gathering done when required by the criminal law team, rather than because you decided you should do further inquiries or evidence gathering?
It would be on instruction. If I had been required to do something, that would come, I believe, from the criminal law team.
Were you ever involved in investigating a case which went to trial in the Crown Court, or in any other case in which external solicitors or counsel were instructed to prosecute?
Do you mean at the actual court, attending the court?
Any case where your investigation led to criminal proceedings in which external solicitors and counsel were involved?
I think the solicitors always came from our criminal law team. In the court itself, the barristers were from other chambers, I think it's called, but everything came from our own criminal law team, I believe.
So you don't recall receiving requests, even if those came via the criminal law team, to conduct further investigations, requests coming from prosecuting counsel or an external prosecuting agent?
I can't recall, no.
Were you ever asked to obtain further information as a result of a disclosure request or an assertion contained within a defendant's defence case statement?
I can't recall.
You say at paragraph 19 of your statement that you had to assist the criminal law team with meeting any disclosure obligations, which you say involved compiling a list of all used and unused evidence in the investigation and collating those documents into a bundle. Would that bundle then be provided to the criminal law team?
It would, yes.
Did you understand when you were an investigator assisting the criminal law team with disclosure that you were acting as the disclosure officer in the case?
Yes.
At the time, did you understand that this was a distinct role over and above your role as an investigator, which imposed on you additional and distinct duties?
it was invariably the role of the investigator that did produce the disclosure list and as part of the committal bundle. But I knew about disclosure, that everything you obtained had to be disclosed as used or unused, but I was aware that we had to produce those lists and those documents and supply them to the criminal law team.
Who would you have gone to if you were in any doubt about whether there was an obligation to disclose material?
Back then, I think the first port of call would have been to my team leader, but certainly I would have seen it progressed from there, but initially, certainly the team leader.
Do you recall being aware that when you were acting as a disclosure officer, you had obligations under the Criminal Procedure and Investigations Act?
I believe I did.
Do you recall being aware when you were acting as a disclosure officer that you had obligations under the Criminal Procedure and Investigations Act Code of Practice?
Such a long time ago. I believe that was a role, yes.
And the same question in relation to the Attorney General's guidelines on disclosure.
I don't remember that particular line that you've spoken there. It's not something that comes back to mind.
Were key pieces of legislation which governed the conduct of investigations and disclosure provided to investigators, as far as you can recall?
I genuinely can't remember.
Can you recall ever accessing such legislation when you were an investigator?
It would be easy for me to say yes, but I can't remember.
What about key policy documents governing the conduct of investigations and disclosure? Were these provided to investigators as far as you can recall?
I don't recall.
Could we have on screen, please, document reference POL 30/64235? This is a disclosure officer's report. Is this one of the forms you recall completing when you were an investigator? You can scroll down a little, please, so that we can see the full page. Don't worry about the specific details of this form at the moment.
It looks familiar, yes.
And scrolling back up, please. We can see beneath the case name, the following items are listed on the schedules for this case and may undermine the prosecution case: primary disclosure, assist the defence, secondary disclosure, or are required to be supplied under section 7.3 of the code. Delete as applicable. So this form requires the disclosure officer to identify any unused material which may undermine the prosecution case or assist the defence. Is that right?
Yes.
Was that the question which you applied to the unused evidence gathered during the investigation when you completed disclosure forms to assist the criminal law team? or do you not remember applying your mind to that?
I don't remember that, no. I'll record this. No.
Who made the final decision on whether material should be disclosed in any given case?
That would be the criminal law team.
Would you agree that it was important for the criminal law team to be aware of the existence of all material which might undermine the prosecution case or assist the defence?
Yes.
Did you understand the importance, therefore, of the job you were doing when completing the disclosure schedules?
Yes, I believe we did.
Were you aware when you were an investigator that there was an obligation on a criminal investigator to pursue lines of inquiry which pointed away from the guilt of the suspect?
Yes.
In an apparent shortfall case, did you understand it to be any part of your role to make inquiries into the reliability of the core evidence being relied upon to evidence, for example, theft?
Sorry, I didn't understand that.
When you were an investigator
Yep.
and you were investigating an apparent shortfall case, did you understand it to be any part of your role to inquire into the reliability of the evidence you were relying upon to demonstrate, for example, theft? So specifically speaking,
Oh, I see.
Horizon reports.
I'm not sure that it's a piece of information that I could have obtained, but I'm aware that on where Horizon data was used in evidence, I believe there was witness statement from Fujitsu to say that the system was working correctly at the time of the material time, but I'm not sure how, as an investigator, I would have checked the reliability of the system. But I understood that was part of, it became part of the investigation, yes.
We'll come on to evidence from Fujitsu shortly, but staying with what you understood your role to be in terms of inquiries when you were conducting your investigation. In an apparent shortfall case, where an essential element of an offence to which an investigation related was dishonesty, did you, as a matter of course, make financial inquiries relating to the suspect as part of your investigation?
Would I or did I?
Did you?
I can't remember cases back then, but part of it, no, I can't remember cases back that far. You would have looked at the financial position of people, yes.
In an apparent shortfall case, where a suspect was saying that they did not understand where an apparent shortfall had come from, did you make inquiries relating in particular to the operation, reliability and accuracy of Horizon data?
I can't remember doing that, no.
Was there a checklist of steps to take or any other guidance to ensure all relevant information was identified, collected and sent to the criminal law team in proceedings brought by the Post Office against sub-postmasters?
I don't recall a checklist.
When you first became an investigator, were you aware of the rollout of the Horizon system?
Sorry.
When you first became an investigator, and that was in 2000, and in the early point of being an investigator, were you aware of the rollout of the Horizon system, its introduction?
I knew it was a new system that had come in, yes.
Did you have any awareness of there being bugs, errors, and defects, or any acceptance incidents during the rollout of the Horizon system?
Not that I recall, no.
Were you given any training on the Horizon system at any stage?
I seem to recall some training on how to obtain data off of the system, how to produce the data. But genuinely, that was usually done by the audit team.
By obtaining data, do you mean printing off the
Yes.
reports from
Yes.
the counter in the branch?
Yes.
Could we have on screen, please, paragraph 64 of Mr. Harbinson's statement? That's page 25. Of WITN. Yeah. It's page 25. And at paragraph 64, you say this: in relation to training about obtaining information from third parties, particularly Fujitsu, I do recall receiving training on the processes to follow. However, I cannot recall when and how this training was delivered. I deal further with such processes under the subheading Analysing Horizon Data and Requesting ARQ Data from Fujitsu below. Can you recall how long this training lasted, the training on obtaining information from third parties?
From the Fujitsu training.
But you've referred here to receiving training about
Yes.
obtaining information from third parties, particularly Fujitsu, and being trained on the processes. You say you can't recall when and how the training was delivered, but can you recall how long the training lasted?
No.
Can you remember who delivered it?
I don't remember clearly. It might have been by the of some of the auditors. I don't recall, but I think it might have been by the audit team.
So when you refer to obtaining information from third parties, are you referring here again to the printing out of data from the counters in branches, or something different?
I think that's what I refer to, yes.
Did anyone tell you that there was a duty on you as an investigator to obtain and consider third-party material from, for example, financial institutions and Fujitsu in appropriate cases?
I believe that would have been a part of it, the training, yes, and understanding that you could obtain further Fujitsu data. There was the ability to do that.
You deal with the process by which Horizon data was obtained at paragraph 75 of your statement. Could we turn to that, please? It's page 31. And you say here at paragraph 75, I can comment on how Horizon data was obtained and analysed in more general terms where a cash shortage was discovered during an audit. the relevant Horizon printouts were obtained by the auditor on the day at the branch. If anything further was required during an investigation, for example, printouts from an earlier period to determine at which point the accounts no longer balanced, then you could receive this information directly from Fujitsu. An investigation manager could simply ask the case management team to make this request to Fujitsu. In general terms, did you consider that the Horizon printouts obtained by an auditor, the counter-printed reports, were sufficient evidence of a loss?
Sorry, the last bit.
Were sufficient evidence of a loss? So the printouts that were obtained by the auditor, in general terms, did you consider those to be sufficient evidence of a loss alone?
Yeah. Yes, they were evidence. I would consider them evidence of the loss, but depending on, if it was me investigating, depending on what the came up on interviews, you might need to go back further to established and to look at further documents and go to the casework and obtain further data.
What guidance was given to investigators to assist them in obtaining Horizon data from Fujitsu?
I don't know what guidance was given.
Or do you recall there being any, apart from being aware you could request data?
Yeah, I knew you could that further data could be requested. I'm not sure you need what guidance there was on that.
What further data or audit reports did you understand could be produced by Fujitsu over and above the printouts?
I genuinely don't remember.
Were you ever made aware that an enhanced interrogation of the audit trail could show when a transaction or event had been performed by the system?
I'm not aware of that.
Who was responsible for deciding whether to retrieve Horizon data from Fujitsu?
I think initially would be the investigator, but further that might come from the criminal law team might advise you to get further data. But on a case by case, I don't know.
Were there ever circumstances in which you would request more detailed audit data from Fujitsu before you interviewed a sub-postmaster or a member of their staff?
I don't recall that happening.
Was that step ever taken before a decision was made to prosecute?
I don't recall.
Were you aware that there was a quota placed on audit request queries made of Fujitsu?
No.
At paragraph 75 that we've just looked at, you describe processes for obtaining Horizon data in the context of cases where a cash shortage was discovered during an audit. But you say at paragraph 74 of your statement that you do not ever recall a situation where a cash shortfall that you were investigating was attributed to problems with Horizon by anyone subject to the investigation. By that, do you mean that you cannot recall anyone saying the shortfall is caused by problems with the system?
I don't recall that, no.
When you were an investigator, were you aware of any other investigators having investigations where a shortfall was attributed to problems with Horizon?
I don't recall.
Did you ever have an apparent shortfall case where someone was saying they simply couldn't explain how an apparent shortfall had occurred?
No. Not that I don't recall that, no.
Were you ever aware that there were bugs, errors or defects in the Horizon system which had the potential to cause discrepancies in branch accounts?
Certainly not, no.
Would you agree that it was critical for investigation managers and those overseeing investigations to be informed of any ongoing technical issues with the Horizon system?
Yes.
You refer at paragraph 76 of your statement to believing it to have been common to have a Fujitsu manager as an expert witness in criminal proceedings relating to cash shortages, to provide their own analyses on the data and to determine whether Horizon was operating properly. What is the basis for that belief?
I believe that they were a witness at any trial, if not in attendance, but certainly part of the committal bundle would contain a witness statement. That's what I always thought and always believed occurred, because it was a question of the reliability of the evidence that you were producing.
Do you recall when a Fujitsu manager was engaged in this way, before or after a charging decision?
I don't know.
Do you recall the name of any Fujitsu manager engaged in that way?
No.
Were you ever involved in providing instructions to any Fujitsu manager engaged in this way?
No.
When you use the term expert, are you referring to the status of an expert witness in legal proceedings, or do you mean that they had expertise in the system?
I thought it was because they were an expert. They were producing a witness statement or in person as an expert on the system and the reliability of the system at that particular time.
Would such a statement usually simply produce audit data or Horizon helpline call logs, or would they include specific analysis of the data or call logs in that specific case, as far as you can recall?
I don't recall the specifics of their statement.
Turning please to the compliance manager role you held in 2005. You say in your statement that you were internally promoted to this role in early 2005, is that right?
That's correct.
Who did you report to in this role?
David Pardo.
And what did your role entail?
Oh, to start with, I was uncertain about what it was that I was doing, but it was really panned out as the compliance of the case file, the construction and timings of case files, to try and raise the standard of of the file itself.
Can you recall now the type of forms you would have expected to see an investigator completing?
Sorry?
Can you recall now the type of forms you would have expected to see an investigator completing in 2005?
Some of them, yes, but for me, it was about the file itself, the green file, with how everything was meant to be laid out in it, with the different documents, different appendices, that type of thing.
As a compliance manager, did the issue of the accuracy of Horizon ever arise?
No.
In the short time that you held this role, did you come across the identification codes document that you address at paragraph 73 of your statement?
I knew there was identification codes, but I don't recall that document.
You say in paragraph 73 of your statement that you do recall investigation managers being instructed to assign identification codes to suspected offenders. Does it remain the case that you cannot recall the reasoning behind that?
That's true, yes.
You say at paragraph 73, and if we can just go back a page, please. That you cannot remember seeing this document. Is that at any point that you were employed by the post office?
I don't remember seeing that document.
And is that why you say you cannot recall what your view at the time was of the appropriateness of the codes described?
I didn't see that document, I don't believe. I don't recall that, no. Or its appropriateness.
Moving, please, to your role as a financial investigator. You say at paragraph 22 of your statement that you and Mick Matthews were both put forward for a new role for the security team, that of financial investigator, by David Pardoe. Is that right?
Correct.
And this would have been late 2005, you think?
That's correct.
You say this new role was campaigned for by David Pardoe. Is it right that the purpose of creating the role was to recoup losses through the Proceeds of Crime Act 2002?
Yes.
You and Mr. Matthews were both successful in obtaining the role. Was it initially just the two of you who held that role?
I think Graham Ward was with us for a very short, for a few weeks or month, but where he went back to being casework manager, and it remained as myself and Mick Matthews.
And you had a national remit covering all areas of the UK?
Not Scotland.
You discussed the training you received for the role at paragraph 24 of your statement. Could we have that on screen, please? It is page 8 of the statement. And at paragraph 24, you say this: All training for my financial investigator role was provided under the Asset Recovery Agency, ARA, who at that time were the government department established under the Proceeds of Crime Act 2002, POCA, to take action against those benefiting from crime. As far as I'm aware, the Financial Investigation Unit within POL were one of the first non-police bodies who applied to exercise powers of recovery under POCA. The ARA took the lead in delivering the relevant training to myself and Mick Matthews in order for us to become accredited financial investigators. In doing so, they provided us with a mentor, Elaine Blewett, who was an experienced accredited financial investigator in the police. Initially, we received mentoring from Elaine Blewett and carried out our work under her supervision and accreditation. This continued until we passed the necessary exams in place to become accredited ourselves. I cannot recall what the specific exams were, but I remember them being very difficult and requiring a lot of preparation and application of the knowledge we had gained from our mentoring and experience so far. I was qualified in POCA Parts 2, 4 and 8. You say at the next paragraph, at paragraph 25, that once you passed your exams and became accredited, you were able to carry out your duties as an accredited financial investigator independently. Do you mean by that you no longer carried out your work under the supervision of Elaine Blewett, the police accredited financial investigator?
That's correct.
But you did report to David Pardoe, who was your senior authorising officer.
We did, yes.
And Mr. Pardoe would review and approve any work you had done, where necessary, in line with ARA guidance.
Correct.
You deal with what your role as a financial investigator entailed at paragraph 26 of your statement, about halfway down the page. And you say this: my role as a financial investigator essentially involved the recovery of financial loss suffered by the POL following a conviction for crimes such as theft of POL assets and false accounting. This involved investigating what assets were held by the convicted individual and how they could potentially cover the loss suffered and the likelihood of recovery. In some cases, it also involved making a case for restraint over particular assets found in order to stop them from being dissipated prior to any application for a confiscation order being awarded following a conviction. Any restraint considered would not be done without the approval of my senior authorising officer, David Pardoe, and ultimately the approval of the criminal law team. You go on at paragraph 27. I would also put together an application to the court for a confiscation order. In doing so, I would produce a Section 16 statement completed on a pro forma available from the ARA. Such a statement would attach and address all the evidence obtained during my financial investigation against the convicted individual and attempt to logically set out my reasoning, aims and objectives around obtaining a confiscation order for the judge to consider. It would be passed on to the criminal law team to review and approve. If approved, they would then arrange for it to be served on the defendant's solicitor and filed at court. You say at paragraph 8 that where the court proceeded to grant a confiscation order, it would always be requested that a compensation order be attached for the same amount. And you address this in a little more detail at paragraph 115 of your statement. Can you explain, please, why this was done, the request for a compensation order?
Yes. Any funds obtained from a confiscation order would then go centrally to the Asset Recovery Agency, and that money would be distributed between all those bodies carrying out financial investigations and was used to drive forward further confiscation initiatives throughout the UK. So that money would not come back to Post Office Limited as the loser, in this case the public money. So therefore you were required to attach a compensation order, which then would take the confiscated amount and pay that exact same money in compensation back to Post Office Limited. So it didn't disappear into the Asset Recovery Agency coffers for distribution. It came back to Post Office Limited. There was no double jeopardy. It was the same money.
You say in your statement that the Financial Investigation Unit had no role in enforcing a confiscation order once obtained. Can you just explain why that was?
Once we'd gone through the court process of confiscation and the order was made, it then went to the regional asset recovery teams, whether that's by the Asset Recovery Agency or by the courts themselves. They would follow through, and they were the people programmed to make recoveries once the order was made. It didn't come back to our team. We were kept informed about when money was received and when it was going to come back, and it came back to the criminal law team. But we were kept informed about the process, not the process, but the actual amounts that were recovered. But the process of recovery was outside of Post Office Limited.
You also say at paragraph 30 of your statement that the financial investigator did not play any part in investigating the potential criminal incident. In relation to a number of the specific cases you address in your statement, you were copied into correspondence about the progress of a criminal prosecution. Can you assist with why that was?
I think once it was coming to the financial investigators for confiscation, people just naturally started to copy us in and keep us informed about the process and where we were. It was quite important for us to know the court process, because we needed documents ready so that we could produce them at the sentencing hearing. For example, a section, I think it was a section 18, which is a provision of information which would have to be served on the day. So we would need to know when, what stage cases were in the prosecution process. But they kept us informed of all those types of, once the cases were going to be picked up by the confiscation team.
You say at paragraph 30 that the financial investigator might start the recovery process earlier than post-conviction in cases where a sub-postmaster had admitted to actions of theft or false accounting from the outset. Is that right?
That's correct.
And you say in your statement at paragraph 31 that when Mr. Matthews left the post office in late 2006 or early 2007, you were left with the entire financial investigation caseload. Do we take it from that apart from the short time you remember Graham Ward being involved, until that point, the financial investigation team consisted of you and Mr. Matthews reporting to David Pardoe?
That's correct.
But after Mr. Matthews left, 2 others were brought in to help manage the workload.
That's correct.
And those other 2 were Paul Southern and Graham Ward?
That's correct.
At that point, is it right that you became Financial Investigation Unit Manager, and you trained Mr. Southern and Mr. Ward to manage their own recovery cases?
I did. I took them through the same process that we went through, with the Asset Recovery Agency taking the lead role in the examinations and training as well.
So they had the same experience that you did?
Yes, but I was their mentor.
I see. Was it at this point when the Financial Investigation Unit formally came into being, when Mr. Matthews left and you were given 2 other people?
Sorry.
So prior to this point, had the Financial Investigation Unit existed formally as a unit, or had it just been you and Mr. Matthews doing the work?
Before we were a team together, Mick Matthews and I, and the team became 3 people when it was myself, Graham Ward and Paul Southern. But that was the Financial Investigation Unit, yes.
And had you always been known as the Financial Investigation Unit from the point you and Mr. Matthews took up your roles?
I see where you come. I'm not sure when the word unit was added on, but I think probably you're right that when there was 3 of us.
You went on to become the Senior Authorising Officer for Mr. Southern and Mr. Ward.
That's correct.
And you say at paragraph 42 of your statement that the Financial Investigation Unit sat within the investigatory arm of the security team.
That's correct.
But its role was distinct from the role of investigation managers.
That's correct.
Sir, I have reached the end of one topic. I wonder if we might take our morning break at that point, slightly
Yes,
earlier than
certainly.
usual.
Yeah. So what are we going to do? Begin again at 11:25?
Yes, sir. Thank you.
Fine, thank you.
Hello, sir. Can you see and hear us?
Yes, thank you.
Mr. Harbinson, you deal at paragraph 45 of your statement with policy and guidance applying to the work of financial investigators. Could we have paragraph 45 on screen, please? That's page 18 of Mr. Harbinson's statement. You say, I have been asked to set out the legislation, policies and/or guidance that govern the conduct of criminal and financial investigations during the period I worked within the security team. When I worked as an investigation manager within the security team, I do not remember any particular internal policies or guidance that governed the work I carried out. I believe that policies were created and introduced over time, but I am unable to pinpoint when or what they related to. I can only rely on the policies provided to me with the request, and as explained above, most of those policies post-date my time at the POL. However, as I was investigating incidents that may have a potential criminal element, which involved carrying out interviews under caution and taking witness statements during an investigation, I was, of course, required to understand and adhere to the Police and Criminal Evidence Act 1984 and the PACE Codes of Practice. There were other acts that I had to refer to, and whilst I would not be able to reference these from direct memory, I believe it would have been all the legislation listed in section 3.15 of the document. At paragraph 46, you talk about the Financial Investigation Unit, and you say again, when I joined the Financial Investigation Unit, I believe there were no internal policies or guidance to govern our area of practice in place. We were a new subsection within the security team. Therefore, internal policies and guidance documents were yet to be created. We relied on the policies and guidance put in place by the ARA, which our police mentor, Elaine Blewett, would have made us aware of. Unfortunately, I cannot recall what those specific policy or guidance documents were, especially as they evolved continuously in line with the developments to POCA and changes within the ARA itself. When you stopped being supervised by your police mentor, how would you have been made aware of any changes in policy or guidance?
the recovery agency continued and maintained contact with us, as they did with all other financial investigators, and there was continual updates sent to us. Later on, I recall that they gave us weekly or monthly tests. They sent us changes in Proceeds of Crime Act. They kept us informed with changes and updates. So we were always in contact with the Asset Recovery Agency and their trainers.
You say you would have relied heavily on the Proceeds of Crime Act itself to ensure you were carrying out your practice appropriately.
Absolutely.
And this was the central piece of legislation that governed your activities as a financial investigator.
Yes.
You note in your statement that the policy documents which do specifically relate to financial investigation policy post-date your time as an employee of the Post Office. There is, however, an undated document which you were provided with for the purposes of preparing your statement, which you describe as an early attempt at a process map relating to the work undertaken by the financial investigation team, in line with the guidance put in place by the ARA. Could we have that on screen, please? The reference is POL 000 84989. The title is Security and Investigation Debt Process Text. The document is, as you observe, undated. It has two sections, one starting on the first page, dealing with security and, dealing with security and investigation, financial investigation unit, criminal debt recovery process for amounts under £25,000. Then on page 11 of this document, please. There is a section dealing with security and investigation criminal debt recovery process for more than £20,000. Going back to the first page, please. Towards the end of the first paragraph here, there is a reference to you being the Financial Investigation Unit Manager.
Yeah.
Based on the reference to the Joint Asset Recovery Database, which you think the Post Office only started using from 2009, is it right that you think this document is likely to have been created at some point in that year, in 2009?
I believe so. I'm not sure when this document was created.
Well, if it assists to look at your statement. It's paragraph 41 of your statement. And you say the reference to you as a Financial Investigations Unit Manager indicates the document must have been created at some point from 2007 onwards.
And jarred, yeah. I understand now, yes.
And you say it's most likely to have been created sometime in 2009, as it refers to the Joint Asset Recovery Database.
Yes.
JARD was a system maintained by the ARA to log the actions taken in a financial investigation and was implemented later on in my career, but you believe that the Post Office only started using that from 2009 onwards.
Correct.
So that's the basis on which you say you think this document was likely created in 2009. As far as you're aware, is this the first policy or guidance document that dealt with the role of the Financial Investigations Unit?
It's the first one I've seen, and I don't recall this one.
You say you don't recall it. Have you had a chance to read through the processes set out in it for the purposes of preparing your statement?
I've read it through, yes.
And as far as you can recall, do the processes set out in this document reflect the processes which were followed during the time you were the Financial Investigation Unit Manager?
I think so, yes.
You say at paragraph 59 of your statement that although financial investigators would provide an opinion on the best mode of recovery, you never made the ultimate decision on whether criminal enforcement proceedings should be pursued. Who did make the ultimate decision?
It would be the criminal law team and the senior people within the investigation team. It usually came back to us from Dave Pardoe, who was the senior person managing myself and the team. But it came from, I believe, the criminal law team or seniors in the investigation team.
As far as you can recall, was any application for a confiscation order prepared by you not approved by the criminal law team?
It was always had to be approved. A confiscation order had to be approved by the criminal law team.
But where that was being proposed, because you drafted up paperwork proposing a confiscation order, did the criminal law team ever disagree with the proposal that a confiscation order should be sought?
I wouldn't draw up a section 16 if it hadn't already been agreed that that's where we were going.
In terms of the possible modes of recovery, as you term them, can you explain, please, the difference between a restraint order and a confiscation order?
Yes. A restraint order restrains an asset and prevents a person from disposing or reducing that asset until it's resolved in the courts, whereas a confiscation order is the order made by the courts to remove the benefit of a criminal conduct in an order.
What were the considerations in play when it came to restraint orders?
It had to be proportionate. There had to be a realistic asset to restrain, a benefit within it. But it had to be proportionate. You wouldn't restrain a property for a few £1,000s or a bank account for a few £1,000s. There had to be a proportionate effect, and there had to be consideration made to the defendants living, their ability to live normally within that restraint. So you wouldn't block them from living. You were trying to secure assets that could be used to service a confiscation order in the future.
Where a decision was made to pursue a restraint order, what was your role in relation to the process?
As the financial investigator, I would have to come to a rationale about why I wanted to restrain. What was the objective in restraining the assets? I would have to get the agreement of the senior authorising officer, and I would then have to take it to the criminal law team for them to agree for an asset to be restrained. I'd then have to write up the restraining order myself, and I'd have to present it in court for a judge to authorise the restraint. Then I would have to return that back to the criminal, but that would have to be then served on the defendant. Basically, I think I've run through about all I meant to, as I recall. That would be my job, but it would have to be authorised. It would have to be signed by a judge. All those things would have to be in place.
What were the considerations in play when it came to confiscation orders?
The confiscation order needed to list all the assets available for the confiscation. We'd have to list what the confiscation, what the amount was that the confiscation was for. That would the financial investigator would have to. There was quite a process before you arrived at it, but you would have to write the Section 16 statement, and having obtained all the documents, and that would all have to be served on the defendant. They would have an opportunity to reply to that, and the court may have made an option for a further response for the Section 16, but it would then go to court, and the order would be made one way or the other.
You deal at paragraph 58 of your statement with the case for confiscation, where a conviction was for false accounting.
Yes.
Could we have that on screen, please? It's page 23 of the statement. And at paragraph 58, you say, although not impossible, it was a lot harder to justify a case for confiscation where a person had been convicted for false accounting. This is because confiscation essentially relates to removing the convicted person's benefit that they received as a result of criminal conduct in order to recover the losses faced by the poll. It would be extremely difficult to work out what the benefit received actually was in a false accounting case. When you say it was a lot harder to justify a case for confiscation where a conviction was for false accounting, do you mean in comparison to a conviction for theft?
Yes.
Can you explain why it is easier to achieve a confiscation order following a theft conviction, please? You deal with this a little further at paragraph 109 in your statement.
I understand. Because on a theft, you have a figure of benefit by of the criminal conduct. And so it's quite easy to set out your objective in the confiscation order to say, I want to recover that figure because that's the figure that was involved in the theft. Whereas in false accounting, you've got to come up and arrive at a figure, how the person benefited by that figure in a false accounting. So that one is easier than they're not impossible, but one's easier than the other.
Could we have on screen, please, document reference POL 001 21639? This is a presentation handout which you comment on at paragraph 66 of your statement. You describe it as being an attempt to raise the understanding and profile of recovery through POCA and the role of the Financial Investigation Unit within the Post Office. And the title here is Financial Investigations Partnership for Recovery, your name and Graham Ward's on that front slide. Was this presentation delivered to the Post Office criminal investigators?
I don't remember this. I can see that we produced it, but I don't remember it. Its purpose would have been to go out to the investigation teams.
Do you recall being involved in producing the content of this?
I don't recall being involved in producing the contents of it, no.
Do you think that you were, given that your name appears on the front?
Most likely, yes.
Could we turn to page 14 of this document, please? The heading on this slide is "How can I make the offender pay when the courts don't ever award compensation or costs?" Brackets, get the offences charged right. And the slide goes on as follows. The first bullet point, theft, fraud and money laundering offences support the POCA 2002 and Criminal Justice Act 1988 confiscation process and in consequence recovery of the loss. Bullet point 2, settling for false accounting as the predicate offence creates massive problems with recovery. Brackets, what is the offender's benefit? Bullet point 3, the investigation and the interview should be programmed to establish what has happened to, what is and where is the criminal property, what offences have occurred, and to what extent others are involved in those offences and or have benefited. Is this you sharing your view, expressed at paragraph 58 of your statement, with the criminal investigation team? Namely, that it was harder to get a confiscation order for false accounting than it was for theft and other offences?
I think that's it within it. I don't think that's the extent of it, of my view there.
Could we have on screen, please, page 3 of this presentation? This covers the fraud team's recovery objective for 2007 to 2008. And the first bullet point says, deliver casework effectively to ensure 30% loss recovery or greater is achieved 2007 to 2008. It would not be unreasonable to project future fraud strand recovery targets to increase year on year. The next bullet point, deliver casework effectively to ensure 35% loss recovery or greater is achieved 2008 to 2009. 3, deliver casework effectively to ensure 40% loss recovery or greater is achieved 2009 to 10, etc., etc. Is it fair to say that recovery was a key goal for the fraud team?
It was a goal for the financial investigation team. I would have hoped that it was that more investigators would look at the recovery side of things.
Could we have on screen, please, POL 000-51539? Looking, please, at the email about halfway down the page from Phil Taylor, a legal executive in the criminal law team, to Warwick Tatford, counsel in the case to which this email relates, the case of Seema Misra. This is dated the 22nd of May 2009, and the email reads as follows. Hi Warwick, I am just a little bit in the dark about Misra. You will recall that there is one count of theft and some false accountings. The defence will plead guilty to the false accountings, and John Longman is fairly happy for us to accept those pleas. However, we are some £70,000 odd light at the moment, as I understand it, and if we just accept the false accountings, it is very difficult for us later to obtain a confiscation order and subsequently compensation out of the confiscation. Could you let me have your views on this? I'd be very grateful to hear from you. Did you share your view on getting the charges right and the difficulty of achieving a confiscation order off the back of a false accounting conviction or plea with the criminal law team? Do you remember having any discussions with them about that?
I think later we see a document where I exactly say that to the criminal law team. I'm not surprised by that, no.
You provided some advice on confiscation in relation to the prosecution of Josephine Hamilton, and you deal with that at paragraphs 106 to 110 of your statement. Could we have on screen, please, document reference POL 000-49154? This is a memo from Juliet McFarlane, so scrolling down please to the bottom. Principal Lawyer, Criminal Law Division, to the investigation team, scrolling up to the top please. Copied to you among others, including Graham Brander and Dave Pardo. It is dated the 15th of November 2007. And we see there it relates to the case of Josephine Hamilton. And it reads as follows: I refer to previous correspondence regarding this matter. As you know, there has been some discussion as to whether or not pleas to false accounting would be acceptable. I note this would be agreeable, providing that Mrs. Hamilton were to repay the full amount. On Council's request, this matter has been listed for mention on the 19th of November 2007. The purpose of this is to see whether or not the trial can be vacated. It is possible that Mrs. Hamilton may wish to enter pleas to false accounting. I understand, however, that she is not yet in a position to repay and has not given a date as to when this can be done. One option would be for the theft count to be left on file, pending payment by the date of trial or some later date. And then in bold, Jed, could you let me have your views as to confiscation in this matter, and if appropriate, the prospect of recovery under such an order? A copy of the indictment is attached. Do you recall giving advice in this case now, or are you reliant upon the documents?
I'm reliant on the documents.
Your response was provided by email on the 16th of November 2007. Could we have that on screen, please? It's POL 000-49168. And it's page 2 of that document, please. You see the email from you to Juliet McFarlane, copied to Graham Brander, the 16th of November 2007. And you say this: Juliet, thank you for your memo. I am never confident with false accounting charges in relation to recovery under POCA 2002, and the theft charge makes life so much easier. The defendant has general criminal conduct under the proposed charges, and this would be so with just the false accounting. However, we have been challenged once before when proceeding to POCA, where only false accounting was charged, and I would probably be more inclined to accept particular criminal conduct when dealing with confiscation in that scenario. I fully understand the balance of cost in court time against recovery, and if the charge of theft was dropped for a guilty plea, then I would still believe it appropriate to follow to confiscation and ask for a benefit figure of £40,201.58, brackets increase in the value of money. Then you deal with the apparent assets in the case, and at the bottom you summarise your opinion. And your opinion is 1, charge her with theft and go to confiscation, or 2, accept a plea of false accounting and go to confiscation. 3, if she pays us before, we can always draw back out of the case, but we need minimum £40,201.58. What stage did you understand the proceedings to have reached when you were providing your opinion? I know it's difficult casting your mind back now.
I can't recall exactly. I would imagine we were looking at sentencing, right? Sorry, no, that's not right. Looking at going to court. But I'm really not sure what position we were at there.
But you and
I think we must be in a position where criminal proceedings had started.
Yes.
Therefore, a charge had been laid, because counsel is talking about getting it listed for mention a couple of days later, isn't he, to sort it out. So there clearly are charges by this stage.
So you were not being asked to advise in relation to what charges should be brought in the first place here, were you?
No.
But asked to advise in the context of whether the theft charge should be dropped?
No. I think I was being asked my opinion on how it might affect confiscation.
Indeed. Do you recall ever being asked to advise on the confiscation implications of potential charges at the time that a reviewing lawyer was making the initial decision whether to charge a suspect, and if so, with what?
No.
Going please to page 1 of this document. Towards the bottom of the page, there's an email from Juliet McFarlane to Graham Brander, dated the 16th of November 2007, and it is copied to you. And the material parts of it read as follows. Graham, I have forwarded Jed's memo to counsel Richard Jory. I have informed him that whilst there is no outright objection to proceeding with false accounting, there is a concern as to recovery of money. We have to date been able to recover where false accounting only is charged, though on 1 or 2 cases the defence will argue against. Whilst a plea to theft would be preferable, in the event of non-payment, the intent would be to proceed to confiscation. And then at the top of the page, the first page, please. We have an email from Graham Brander to Juliet McFarlane, dated the 19th of November. And it reads, Juliet, Ref Hamilton mention hearing 19th of November 2007, Winchester Crown Court. Richard Jory advised me earlier today that he hadn't received this email. Any chance you could forward it to him again? Hamilton pleaded guilty to the 14 FA false accounting charges. Agreement by both counsels that provided full amount. I advised Richard of increase in value of money is repaid by sentencing date, 25th of January 2008, then the single theft charge would be dropped. Richard stipulated that if the full amount wasn't repaid by that time, we would go to trial in respect of the theft charge, unless it could be shown that payment would soon be forthcoming, in which case sentencing would be adjourned. Had you ever intended that your view would form the basis of a stipulation that all sums should be repaid in order to avoid a theft trial?
No.
Are you aware now that the way this was dealt with, that making repayment a condition of dropping the theft charge, was criticised by the Court of Appeal when it overturned Mrs. Hamilton's conviction?
No.
There is a memo from Juliet McFarlane, also dated the 19th of November 2007, which you were copied into. Can we have that on screen, please? The reference is POL 000-44388. We see that this memo goes to the investigation team, copied specifically to Graham Brander, you and David Pardoe. And it reads as follows. This again relates to the Josephine Hamilton case. The defendant appeared before the court today. The prosecution was represented by Mr. Richard Jury of 9 to 12 Bell Yard, and the defendant was represented by Anita Saran. The defendant pleaded guilty to the false accounting counts 2 to 15 on the indictment. The case has been adjourned to the 25th of January 2008 for pre-sentence reports. The defendant has been informed that full payment must be made prior to that date. The theft count has remained on file on the understanding that it should be proceeded with if the money is not repaid. It is believed that the defendant has monies which will be available at the end of the year. If the defendant does not repay, then consideration will need to be given to the practicalities of proceeding with the charge of theft, or whether confiscation proceedings should pursue. I note that the compensation outstanding is £36,644.89. I note that the figure canvassed of £40,201.58 is a sum which includes interest. The greatest sum will no doubt be pursued should confiscation proceedings be brought. And then this. It has been made clear to the defence that there must be some recognition that the defendant has had the money short of theft, and that a plea on the basis that the loss was due to the computer not working properly will not be accepted. As stated above, the next hearing is on the 25th of January 2008. Do you now recall Mrs. Hamilton raising allegations that the Horizon system was not working properly?
No, I don't remember that memo.
You were being told, among others in this memo, that a plea on the basis that the loss was due to the computer not working properly would not be accepted. Can you recall whether you formed any view at the time on the appropriateness of that?
No.
What is your view on the appropriateness of that as you sit here now?
With the knowledge of where we are now, then it's what probably wasn't, well, not probably, it wasn't appropriate.
Was this a post office line to take, that the computer not working properly was not to be entertained as a defence to a criminal allegation?
It's something I'm not aware of, no.
Could we have on screen, please, document reference POL 001192228? This is a memo dated the 16th of September 2009, and scrolling down, actually we can see there, from Paul Southern to the fraud team, and it's copied to you. Scrolling back up, please. It reports on the outcome of a case and the first paragraph reads as follows. Following successful negotiations between the FIU, the investigator, and the solicitor representing the defendant, the full amount of the loss, £27,407.33, was repaid via a backs payment into a bank account of Post Office Limited. Was it common for the Financial Investigation Unit to be involved in negotiations in the context of criminal investigations?
No.
Can you help with why the FIU was being referred to there as being involved in negotiations?
No, I don't know whether Paul Southend is referring to himself or as the team, but I don't remember that.
Where a confiscation order was pursued, did your role involve anything over and above the steps you've already discussed in relation to confiscation proceedings?
No.
You have been provided with a number of memos among the documents which have been provided to you quite recently by the inquiry, which suggests that you were notified following an audit where shortfalls were identified on some occasions. In what circumstances would the Financial Investigation Unit be notified following an audit?
You mean by the auditors to us, or just following an audit?
Well, either by the auditors or by someone else following an audit, but at that stage of proceedings where a shortfall had been identified on an audit.
I think normally we'd be informed once there was an investigation into a loss over a certain amount, but normally it came later than that. But normally we're informed once there was an investigation into a loss.
Also, among the documents more recently provided to you by the inquiry are a number of memos which suggest that because a case was not being criminally investigated or prosecuted, the late account team should pursue any outstanding losses. Does that represent a default position on the part of the Post Office to pursue a suspect via a criminal investigation or prosecution? And if that failed, to refer to the suspect's case to the late accounts or debt recovery team?
I'm sorry, I don't understand.
Are you aware of the memos I'm referring to, where there is a one-liner essentially saying no further action is going to be taken? The matter should be referred to the late accounts team,
yes.
So the debt recovery team on the civil side.
Yes, I saw that document.
Yeah. My question is whether that reflects a default position of the Post Office, initially to pursue a suspect via a criminal investigation or prosecution, and if that failed, to refer their case to the late accounts debt recovery team.
Not that I'm aware of, no.
Sir, those are all the questions that I have for Mr. Harbinson. I'm turning to see whether CPs have any questions. Mr. Jacobs?
I do have a question, yes, thank you. I act for 156 sub-postmasters, one of whom is the widow of Peter Holmes. And you deal with his case in your statement at paragraph 159. Do you recall?
No, no, I don't recall.
Prosecution of Peter Holmes. Maybe we could turn then
Yeah.
to your statement at page 159. That's 63 of 78. Have that on the screen, please. You see that prosecution of
Yes.
Mr. Peter Holmes. And you are taken to at paragraph 162. You say that you've reviewed emails dated the 30th of January 2009. If we could go to paragraph 162, please. And maybe if we could just pull up POL 000-50817 so we know what you're referring to there. And this is an email dated the 30th of January from you to what appears to be the criminal intelligence team within Post Office Limited. Is that right?
Yes.
And you're authorising checks in relation to Marion Holmes, and we understand that was in relation to her financial matters. What was the criminal intelligence team? Who were they?
They were an internal team that sat in Croydon, who would obtain documents. They had things like for vehicle checks, that type of thing. They go to DVLC and those types of documents.
Now, I know you've said at paragraph 3 of your statement that you don't remember much about the documents that you've been shown by the inquiry. What was your involvement with the criminal intelligence team? What sort of cases did you refer to them, and why would you contact them?
I didn't refer cases to them. They part of your as a financial investigator, as part of your the gathering of information about assets that might be used in a confiscation order. You go to them to get DVLA records about a vehicle to know whether or not it was financed, or whether the make, models, those type of things would come from DVLA. A person's, I can't remember the document, but when you applied for the financial data about somebody, I'm sorry, but I can't remember the actual document, but it would have your history of your payments and things like that. They would be the type of documents that they would be able to receive, but they would you'd need to apply to get those.
Right.
But, and there were the connections within that team that were established with the police and the DVLA and different departments that obtain those documents.
If we could go to paragraph 163 of your statement, please. Sorry to jump around.
Sorry.
That's WITNO 8150100. Paragraph 163, please. Which is on page 65 of 78. And in this part of your statement, you refer to a memo and that is a memo from Ms. McFarlane referring you to an accountant's report.
Yes.
Now, Mrs. Holmes has given evidence to the effect that the Post Office thought that some money that was in her joint account had been taken by her husband and put into that account, and they engaged a forensic accountant, and he prepared a report, and as a result of that report, Mr. and Mrs. Holmes were completely vindicated, and Post Office didn't pursue that further. But the question that I want to ask you is, why was it that you were looking at accountants' reports? Did you have any experience in accountancy or any particular knowledge of that field?
I did not know.
No. And do you recall looking at or analysing an accountant's report in relation to this case or in other cases?
I don't recall that, no.
And this may be a difficult question for
No.
you to answer, but are you able to say why it is then that you were given a forensic accountant's report to look at?
I could only speculate if you want me to do that.
Well, yes.
That because we had the title Financial Investigations, people thought we had greater understanding probably than we did have in some cases. And I think Juliet may well have been saying, look at this, what's your opinion, rather than me having a great understanding of what it was. And I think I know we can't ask Juliet, but I really don't know why she sent it to me. I can't remember that.
Now, the Court of Appeal found that Mr. Holmes' prosecution had been an abusive process. They found that ARQ data had been obtained, but it wasn't clear whether it was disclosed, and they found there was no evidence to corroborate Horizon evidence, no investigation into the integrity of Horizon figures, and there was no proof of any actual loss to the Post Office. Was this information that you would have been a party to or aware of at the time when you were involved? No.
No, sir.
And finally, at the end of your statement, paragraphs 166 and 167, we don't need to turn these up. You say, I wasn't aware of any concerns regarding the robustness of the Horizon IT system during my entire career with the Post Office. As far as I was aware, the system operated as was expected. And then you go on to say, if I'd ever been aware that there was a potential problem with the robustness of the system, I would have raised this with senior colleagues and flagged to them that, in my opinion, any criminal investigation would need to cease. Now, the sub-postmasters and mistresses that we represent are very keen to know the names of the individuals who were the decision makers, who would have been able to put a stop to prosecutions once it became clear, or once it should have reasonably become clear, that there were problems with the system because of what sub-postmasters were saying. So my question for you is, can you name the senior colleague or colleagues to whom you've referred who you would have discussed any potential problems with the Horizon system with a view to stopping prosecutions if you come to know about these problems with Horizon?
Well, thank you. I think, sir, that if as an investigator I'd become aware of something like that, I would have spoken to my team leader straight away. If as a financial investigator I was aware of that, I would have spoken to Mr. Pardo. But you know, that information would have to go up, wouldn't it? You feed up.
So would Mr. Pardo, for example, have had the authority to investigate and put a stop to prosecutions on the basis of what he was being told from people like you in your position? Or would that have had to have gone up?
I think Mr. Pardo, a question for Mr. Pardo, but I think it would need to go up further, yeah.
And what about Mr. Utting and Mr. Scott? Are they people that you might have spoken to?
It's unfair of me, I think, to speculate on what their positions were, sir.
The question I'm asking is, who would you have gone to, regardless of what they would have done?
As an investigator, I'd have gone to my team leader. As a financial investigator, I'd have gone to Mr. Pardo.
Who was your team leader
when I was an investigator, it changed a few times. It started off as Tony Utting. There was a guy called Paul Dawkins who was my team leader. There were different people, but that's 20 years ago. So I apologise if
That's quite all right. Thank you. I just need to ask if I have any more questions that I need to ask you. I'm told I don't. Thank you very much.
Sorry, sir.
Anyone else?
So there are some questions from Ms. Page.
Yeah.
Thank you, sir. Just very briefly, Mr. Harbinson, I appear for a group of sub-postmasters also, one of whom being Janet Skinner, who sits beside me on my right. Is that a name that rings any bells for you?
From the documentation, yes.
You've told us about your opinion that it was more difficult to obtain confiscation in cases where a theft charge had been dropped, leaving only a false accounting charge. Yes?
Not dropped, but the difference between a theft charge and a false accounting charge, yes.
Well, in Miss Skinner's case, that was what happened, and the theft charge was dropped, leaving only a false accounting charge. Even so, there was a confiscation proceedings proceeded, and there was an application from the defence saying that those confiscation proceedings were an abusive process. Does that ring any bells for you?
No.
I ask because you've told us that there were cases where there were challenges when the only charge left was false accounting. Is this not one of those cases?
No. No.
What were the cases then that you were?
I don't remember the specific case, but they weren't challenges against confiscation. It's about the amount. What was the value of when it's a false accounting? How did what value did they benefit by? And there's different ways you can work out the benefit figure. It's not always totally just the amount that's gone, but you can benefit from continuing to receive pay, having false accounted. So the person's payment, because, so they maintained their job, their money after that period of time could be considered as benefit from criminal conduct. So I didn't say it's impossible, I said it's more difficult.
Well, certainly in Miss Skinner's case and also in Mrs. Adedayo's case, another of our core participants, it was very straightforward. The Post Office simply proceeded in the same way as it would if it had been a theft charge for the full amount that was the shortfall, or that they said was the shortfall.
Absolutely, because in fairness, it wasn't for the prosecution to talk down the value of the benefit, but for the defence to say, you know, how do you obtain your, you know, what is your benefit figure? How did you obtain that benefit figure? But you would always go for the object of the confiscation within Post Office Limited was to try and recover the loss amount, the benefit as the benefit figure. We didn't go beyond that. A lot of POCA would allow you, in some respects, to accumulate massive benefit figures. The objective of the confiscation was to recover the loss figure.
Can you think of any case where you didn't recover the loss figure, even if it was only a false accounting charge, or the figure that Post Office claimed was the loss?
I can't remember now, no.
The advice then that you were giving to continue with theft charges on the basis of recovery was then based on no cases as such?
I never advised, my advice wasn't to continue on theft charges. My advice was, one is easier than the other. And then, I think if you see underneath, I say, whichever one you do, whatever you do, this is what we should proceed, you know, we should go for these figures. I was giving my opinion. The decision for the charging was for the criminal law team.
Yes, thank you. Those are my questions.
On this issue, of the comparative difficulties of pursuing confiscation in false accounting cases, does it really come to this, that if the charge was theft and there was either a finding of guilt or a plea of guilty, then there was acceptance that the money stolen, say £20,000, was the benefit figure? Yeah? If the charge was false accounting, there would be a variety of ways in which benefit could be looked at, but some of those ways would be that the defense would argue that the benefit figure was nothing like as much as the alleged loss to the post office.
Exactly so, yes.
Yeah. And you were anticipating, quite correctly, that in some such cases, the advocates for the defense would maintain that argument before the court and the court would accept it.
Yes.
So from a purely pragmatic point of view, it was much easier if the charge was theft. That's what it boils down to, isn't it?
Yes.
Yeah, fine. All right, thank you very much, Mr. Harbinson. Thank you for... Oh, sorry, are there any other questions?
No, sir. I think those are all the questions from call participants.
Fine. Well, then, thank you, Mr. Harbinson, for making your witness statement and for giving evidence this morning. I'm grateful to you.
Thanks.
And so we adjourn until Friday. Is that right, Miss Price? And we have 2 witnesses on Friday.
We do. We resume at 10 o'clock on Friday to hear from Diane Matthews, followed by Lisa Allen.
Thank you very much. See you all then.
Thank you, sir.